President and legal fellow for Defending Education, which used to be Parents Defending Education and has now changed its name, take note, and a current trustee of Florida Gulf Coast University in Fort Myers, Florida. And Christopher Shore, director of the America First Policy Institute's Higher Education Reform Initiative and co-author of Black Eye for America: How Critical Race Theory is Burning Down the House. Now, what we are here for is a discussion of, well, we call it a white paper on case resolution agreements. And let me explain to people some of the background for this. By the way, and I have a dual role here as author and moderator. It's going to be so much fun. I won't use the hook on myself. It'll be great. Um, we at National Association of Scholars last year wrote a long report critiquing the education department and how it does business. Wasteland. If we had a series of negative descriptors in the subtitle, but the point is, we were looking at the education department in detail, how it did business, among other things, how they used case resolution agreements to slide progressive policy in without getting any buy-in from, Congress, the people, etc. That was our, for, a major critique of the education department as a whole, both for what it's doing in higher education and K-12 education. We have been following up on this with a series of these white papers, shorter papers that follow up on particular aspects of our critique, talking about new work as well. Um, and I should say, by the way, and all of this thanks to a very healthy and wonderful support from the Arthur Roop Foundation, to which we are extremely grateful. Thank you so much. Um, We've done, for example, something on Title IX. We will be doing work on, say, national interest. This is following up on the case resolution agreements. Now, this is a particular tactic which was used by the education department largely, as I say, for progressive ends. It's been used very interestingly under the Trump administration for education reform ends, rather. And the white paper is meant to evaluate the strengths and weaknesses of this tactic and what education reformers in general should do as a follow-up, given that this is the way they're approaching. So, what we're going to be doing here is I'm going to give a brief version, and I'll try to make this brief, of the meaning of the of the case resolution agreements, what we get out of this. We are then going to get comments from Sarah and from Chris, um, perhaps in that order, unless their preferences to depart from alphabeticalness. Once we have that, there will be a combination of moderated discussion and Q&A. I would dearly love this to be as heavy on Q&A as possible. Therefore, you participants, there are both chat and Q&A buttons at the bottom. Either one will do. I'll look at both. If people start to put in comments in one, I guess it'd be better if everybody else went to the same place. But I will then take comments, based upon interest, not chronology. No offense. Just if something seems like it'll be fun for discussion, I'll go there. Things to note. This is going to be recorded on the National Association of Scholars YouTube channel. That means if you have to leave in the middle, don't worry. You get to see this in perpetuity. Link it to your friends. Publicize it. And anyway, if you wander away, don't worry. You'll be able to see the end. The other thing is, going to have questions. If you have a question that doesn't get answered, or if you have a question that occurs to you later, send email to me, David Randall, Randall at nas.org, Randall at nas.org, and I'd be delighted to pass your questions on to our participants so that they can have the option of answering you. Anyway, just don't worry if you, about any, interruption. Uh, y Discourse, dialogue, and conversation will happen. Now, Having said all that, I'd like to give, I guess, a brief presentation about, following up on, the case resolutions white paper. And I'll just start dramatically. Northwestern University recently struck a deal with the United States Department of Education, and the university is going to pay a $75 million fine and guarantee there will be no more Jew hating on the quad and no race discrimination in the admissions office, or on faculty hiring committees. Then federal money will start to flow again. Can Northwestern be trusted to honor its end of the bargain? This speaks directly to what the Trump Education Department has done by settling on a case resolution strategy to reform America's ivory tower malefactors. The Education Department did earlier actually last year, to release trial balloons that were suggesting direct federal oversight of higher education. That appears to have been a negotiating tactic. The Education Department is going to settle for using its long-standing and frequently abused practice of imposing policy by means of a voluntary agreement with an individual university, an agreement that administrators at every other institution of higher education in the country will take as a hint as to how to behave if they want to avoid a federal lawsuit. And Northwestern is the sixth of six in the year 2025. There were also case resolutions with, and I believe this is chronological order, the University of Pennsylvania, Brown University, the University of Virginia, Cornell University, Columbia University, and now Northwestern. Actually, that's not chronological. Columbia came earlier. So here's what happens generally in these case resolutions. The university pays a sizable fine, tens of millions generally, sometimes hundreds of millions, and then commits to cease tolerating anti-Jewish intimidation, sex discrimination by way of transgenderism, and race and sex discrimination in admissions, hiring, and staffing. It also commits to reviewing its dependence on foreign students and international branch campuses. And then, in many of these, it agrees to join with the Department of Education in selecting an independent monitor who will make sure the university lives up to its commitments. The alternate that's being given is the university president can certify compliance under penalty of perjury. The university is free to run its own affairs. Yet, if it breaks its promises, the independent monitor will alert the education department, which then is theoretically will impose new sanctions. Now, that's the theory. Uh, the college and university bureaucracies strongly dislike the Trump administration reforms they have agreed to undertake, and strongly dislike is unbelievably soft as a way of putting that. Americans can and should expect them to sabotage the case resolutions if they can get away with it. And there's some reason for them to think they might be able to. Independent monitors will have few staff to oversee massive university bureaucracies. University presidents might indeed forswear themselves if they think they can get away with it. The education department is thinly staffed and it's got a great deal of work to do. They may have a natural desire to declare victory and not revisit the issue. The fines on the universities have been substantial by and large, but the universities can survive them, and they're not quite enough to necessarily deter further misbehavior. In any case, the case resolution terms of agreement frequently expire in only 3 years, which in effect is at the end of the Trump administration. So The Trump administration can't guarantee the next administration will follow up. It's not wasting its time by saying, this is going forward beyond that. It's just saying, we're here for 3 years. You've agreed for 3 years. Let's be realistic about this. Going the case resolution route may claw back some money and have the universities engage in limited reversible reforms until they see who gets elected president in November 2028. That's if Americans leave matters to the education department, but they don't have to. And here we get the rousing trumpet cry from our white paper. Independent education reformers can build on the administration's strategy by conducting investigations into how well colleges and universities have fulfilled them, and by organizing publicity and putting political pressure on colleges and universities to ensure that they comply with their commitments. Information gathered by independent education reformers also can give the Department of Education the information it needs to give precise instructions to colleges and universities about what they need to do to fulfill their case resolution obligations. Education reformers acting as truly independent monitors can strengthen university compliance and thereby make the education department's case resolution strategy more effective. For example, if you were an education reformer in Illinois, you wanted to focus on making sure that Northwestern University lived up to its promises, you could use advertisement, a 10-point template drawn up by the National Association of Scholars in our case resolution white paper, which is basically drawn from the case resolution agreement with Columbia, which is by far the most comprehensive of the ones that's been done this year. And there are headline points and concrete metrics for evaluating compliance. So an example, headline, demonstrated non-discrimination for race, sex, and national origin in student admissions. Metric, a detailed annual report made available on a publicly accessible university webpage that shows both rejected and admitted students, disaggregated by race, color, grade point average, and performance on standardized tests in a form permitting appropriate statistical analyses. That's rather formal language, but it would, I think, make a pretty darn good metric. We have 10 of those, and I'm not going to read them all. One will do. But these 10 reforms are by no means everything that must be done to rehabilitate our colleges and universities. Yet they would remove a great deal of the worst lawlessness and discrimination committed by colleges and universities. The Trump Department of Education alone may not have the manpower to execute its case resolution strategy in full at Northwestern, at Columbia, nationwide. Independent education reformers, however, can use that framework to give substance to case resolution agreements. This, I would submit, the NAS would submit, is the greatest promise of the education department's strategy to rein in woke universities. It's duplicable. It's not just that the education department can use it. Anybody can use it. It can be a springboard for everybody to work for it. And one might add, federal policymakers could add an incentive. They could, for example, mandate that whistleblowers and independent education reformers receive 5% of fines for university violations they bring to light. And I should say this is actually standard practice in a number of aspects of our legal system. Whistleblowers, people who rat out people who are committing evil and when there are fines, you give them a cut of it. So we do this standardly, just extend this Corrupt Practices Act to the universities. And Northwestern cannot be trusted to keep its promises to stop race discrimination, sex discrimination, and anti-Jewish intimidation. Right now, alas, no university in America can. Sorry, with rare exceptions, Hillsdale, etc. And it's similar to when the communist governments of Eastern Europe signed the Helsinki Accords in 1975, in which they promised to protect human rights. They were lying, of course, but their dissidents could use their bad faith promises to build for long-term and real reform. Northwestern has signed its Helsinki Accords. So have Columbia, Brown, and a growing number of their peers. Independent education reformers can use their promises to build true and lasting reform that will, within a generation, end the reign of the squalid would-be dictators of the ivory tower. And that's the short version. Thank you so much. I thank myself as the moderator. Moderator thanks me as presenter. Sarah, may I ask if you would be so kind as to go second?
Was great. Very clever way to end that colloquy. I'm so appreciative of the work that the National Association of Scholars does in this area. This is a fast moving area right now of administrative law and procedure, and it's ultimately unprecedented. I was on the inside at the Department of Education as senior counsel to the Assistant Secretary for Civil Rights. I was involved in the case resolution process. And I will tell you that while the statutes under which the federal government has exercised its federal muscle, Title 6, 7, and 9, do, at least in two of them, identify and conceive of the withholding of federal funding for patent violation of anti-discrimination law, we had yet, prior to this administration, ever seen it activated. It was no longer just theory. This was now practice. So there are a couple of table setting things that I'd like to get out of the way as I kind of parse through many of the characteristics of some of these case resolution agreements and whether or not they are truly the best path forward for education reform. So we're really talking about the intersection here between federal oversight, education reform, and compliance, and kind of the intersection of where all of those come together and what it might mean for higher education going forward. Quite frankly, right now, only 32% of Americans have confidence in higher education. That is for sort of a confluence of reasons, not the least of which is they feel as though there's not enough viewpoint diversity, that these institutions have become sort of these mini hegemonies of their own making, where they institutionalize, repeat, and then sort of isolate particular perspectives for favored treatment, most favored nation beliefs for things like anti-Semitic comments or pro-Palestinian content. And the viewpoint discrimination perspective has much to do, I think, with why many people are dissatisfied with higher education right now. They also recognize that there is insufficient respect for national values or principles that we are taught in many respects by a lot of these higher education institutions to despise our own founding history or subject it to revisionist elements. There's really no commitment to the canon of American excellence or our founding principles. And so all of these factors have, I believe, informed the Department of Education and also the Equal Employment Opportunity Commission that has been involved in its own case resolutions strictly related to employment discrimination, but they have worked hand in hand with Department of Education in many of these cases. They have really sort of motivated the departments to become ultimately what I think is the 800-pound gorilla. Now, we can quibble over whether or not that's a good thing, but it has certainly yielded results, unprecedented results. We are still less than a full year into this administration, and we're seeing some significant alterations. We like to say that there are federal funding recipients that fall into one of three categories. One is compliance, one is defiance, and one is concealment. Now, compliance obviously are the ones that are going to immediately toe the line when they get the executive orders, and there have been more than 50 in higher education since January of 2025, so no shortage of applicable executive orders in higher education. They're the ones that immediately come to heel. They recognize we've got to do things differently. We're going to immediately do an about face. This is significantly different from the Biden administration that wanted us to believe that down was up and black was white. And so things have now changed. They're falling into line fairly easily. There are those who are ultimately defiant, and that is where the bulk of our discussions today come in. These are institutions like Harvard and Brown and UC Berkeley and Penn, all of whom that have decided that they will go toe to toe with the administration. And then there is a third group, and this is the group that much of the work our organization does is dedicated to rooting out. It's those in the concealment camp, those where we see, for example, 245 active diversity, equity, and inclusion offices still in operation, despite federal mandate, interpretive guidance, and executive order to the contrary. It's very clear that DEI has no place in higher education, nor did it ever. The Supreme Court made that clear in Students for Fair Admission versus Harvard. The administration has rightly extrapolated that decision and has issued constitutionally sound, statutorily sound guidance to each of these federal recipients. And there are many of them. In fact, most institutions, and again, David, you mentioned Hillsdale as the notable outlier, but most institutions of higher education accept either directly or indirectly, as the Supreme Court has noted. Indirect funding is also funding, whether or not you take, for example, a student on a Pell Grant or you take them on a federal Stafford loan, that is benefiting from the recipients of federal funding. So much of this we've seen sort of take place in concealment. That is, we're hoping, something that those who are still hiding in the shadows will look to see some of these voluntary resolution processes and say, it was long and sort of attenuated and expensive for Brown or Columbia or Harvard. Maybe we don't want to go that route. But this is ultimately, at this point, as you both know, a numbers game. How many universities can you catch with their hand in the cookie jar, actively engaging in malfeasance, and bring them to toe fast enough to be able to, before your administration ends, or heaven forbid, before even the terminus of midterms, which might yield a completely different result for conservatives who are currently in the House of Representatives? How much can you get done in a short period of time? So I want to clarify for those who are watching right now, what is the case resolution process, right? We've jumped right into exactly sort of language around and the efficacy of these precise issues. But as somebody on the inside, let me tell you exactly what a case resolution process is. That kind of an agreement is a voluntary extra statutory mechanism employed by the U.S. Department of Education to drive policy changes at institutes of higher education. Now, they rely on a couple of different criteria. It allows the federal government to withdraw outstanding charges of discriminatory conduct against an institution, against a university, in exchange for their commitment to institute a number of specific self-reforms. And these also can include provisions for external oversight, such as, for example, independent monitors agreed upon by both parties. And that kind of an approach allows the department to ultimately be able to enforce reforms without needing new congressional legislation, formal public comment periods, making it a flexible tool to address compliant issues. Obviously, having been active in the regulatory process, I will tell you, rulemaking, going through the federal agencies, taking those outstanding federal laws and applying them in such a way as to clarify any perceived ambiguity through the notice and comment process. These are months long, sometimes up to years long, and it could be hundreds of thousands of public comments that individuals on the inside at EEOC, at Department of Education, are duty bound to interpret. So if you can cut to the chase with a voluntary resolution agreement, that is always the aim. The goal is always voluntary rectification of discriminatory behavior. You really don't ever set out, at least in my service in the Department of Education, one never sets out to immediately revoke federal funding. The goal is to get two parties to come to the table, like mediation. And you would, as you would in, for example, a divorce proceeding or an employment proceeding, get both parties to the table and engage in a back and forth that will ultimately allow these individuals on both sides to feel as though they have been heard and that they will be in compliance and they have also secured compliance. And under this administration, voluntary compliance doesn't necessarily seem to be the driver. They like to utilize the big stick of federal funding revocation first. I've heard some attorneys argue, and we can debate this, whether or not they have ultimately gotten over their skis in terms of the revocation of federal funding. Some think they have extended too far congressional spending powers, as much of federal civil rights law is. Those types of laws act in the nature of a contract between the federal government and a funding recipient, and those term contracts must be clear. So if, for example, the previous administration allowed diversity, equity, and inclusion and found the same not to violate Title VI of the Civil Rights Act, but this administration finds it to be a violation of Title VI of the Civil Rights Act, well, those things have to be clarified by rulemaking. And we will see just that. The spring regulatory agenda has been published, and one of the rules under consideration and development at present is the elimination of disparate impact within the aspect of race-based programming in higher education. In other words, something that is facially neutral, but might have a disproportionate effect on one racial group or another should not be treated as a form of race discrimination. Only intentional race discrimination should matter. Now, this is how the negotiating process generally unfolds. The department leverages tools like executive orders and the threat of withholding federal funding to apply pressure first on non-compliant universities. And that often occurs in concentrated periods of time. Again, for the Trump administration, this was really summer and fall of 2025. We're really coming out of an unprecedented period of sort of locking of horns between the academics in ivory tower academia on the East Coast and the West Coast and the Trump administration, both of whom had very different views on the best way to manage, regulate, and reform higher education. A lot of these universities who are facing financial and legal risks or who want to truncate the litigation process, if it should get to that point, enter into these negotiations where they agree to the dropping of the government's charge of discriminatory action in addition to paying in exchange for paying fines. Now, these can be formal or informal and implementing extensive internal reforms. Compromises are very, very common. Again, this works in the nature of mediation. It's a back and forth discussion. For instance, a university might rightly back away from demands from the Department of Education for more direct involvement in university governance. We want universities to be independent. I serve on a university board, as you heard in today's introductory comments, and really the goal is to get universities to behave well, but to behave well independently. The process generally emphasizes university-led implementation with built-in accountability measures, annual reporting and audits, for example, and again, relies very much on an institution's willingness to follow through, particularly so in this generation of the administration, because we know that Department of Education has been significantly downsized. We are currently without an installed general counsel at the U.S. Department of Education. We've had various acting general counsels, but no statutorily affirmed general counsel. Jen Mascott, who was appointed by President Donald Trump, was eventually nominated to the Third Circuit Court of Appeals, where she's already taken the oath and is already on the bench. But we've also seen a reduction in force or a riffing of 7 regional field offices. In my role at Department of Ed, I oversaw 12 regional field offices, so cutting that number down to 5, in addition to some significant layoffs at headquarters in Washington, D.C., has substantially impacted the opportunity to be able to accomplish things at the Federal Department of Education. So again, they are trusting that once the heavy duty lifting, the muscle is applied in these particular instances with these higher education institutions, that they will willingly go forward in compliance and that they will be good little boys and girls when the Department of Education has to turn its attention to other things. Now, the administration, obviously, as we're going to talk about, has made significant efforts to ensure compliance through these agreements. It's incorporated robust monitoring and transparency requirements. We're seeing now kind of a corollary, a supporting secondary step after the voluntary resolution agreements. They've got metrics for success that are very easy to follow. Okay, these are essentially enforcing non-discrimination in admissions and hiring, eliminating discriminatory programs, and achieving specific reductions in financial dependence on international students. For example, a 20% decline, I believe the administration has set out in both proportionate and absolute terms compared to the 2020-2021 fiscal year. But the supporting efforts we've seen are two of them. First of all, rulemaking on transparency in admission metrics for higher education. This is a tremendous opportunity, I think, for the Department of Education to finally achieve some clarity, some transparency, a real sort of informed consumer approach to higher education by processing data on admissions and scores, demographic makeup of those students, the total cost, these kinds of things. And I speak as a mother of two in college and another on the way. These are the kinds of aspects that are going to make these voluntary resolution agreements less and less necessary, because if transparency is ultimately secured by things like rulemaking on data, which is underway for the spring regulatory agenda, parents like myself, students like my kids, will have an opportunity to make an informed decision about their choice of a higher education outlet. It's going to secure a better ROI, because if, for example, my son recognizes that the class proportionately from the previous year represented one minority over another, even though those scores might have been, for example, significantly lower than another group's, that's going to come into our decision making to determine whether or not he has a truly fair shake at admission coming to this university. Another supporting corollary to these particular case resolution agreements are the new reporting funnels, those portals. One started on January 2nd for higher education foreign funding. Again, transparency here being the key. It's going to prevent a lot of these involuntary/voluntary resolution agreements, because once we have the data, it'll be a lot harder to hide malfeasance. Section 117 of the Higher Education Act mandates post-secondary institutions to report more than $250,000 biannually of foreign gift funding. And since the launching of the portal on January 2nd, so far we've had $62.4 billion in federal fund or foreign funding disclosed. That represents a total of 117,000 transactions, 194 nations, and 527 different colleges and universities. Not surprisingly, for anybody who hasn't visited the portal, Qatar is coming out at the top with $6.6 billion accounted for so far. And again, the portal's only been operational for about 13 days. So we are automatically looking at significant exposures for foreign funding. Whether you think that's good, bad, or indifferent, it is a significant criteria to higher education that is something we're going to need to assess going forward. Following Qatar, or Qatar, as we're now all saying it apparently, Germany, England, and China, in that reverse order, are actually the other highest funders. These two efforts are certainly bolstering resolution agreements. The admins also engaged in external education reformers for additional oversight, investigation, public commentary through rulemaking, public pressure. And again, all of these have to be taken into account based on the limited budget and manpower we have currently at the Department of Education. Now, the goal here is to foster institutional self-reform. It's very hard to tell an independent agency, listen, you have to get your ducks in a row. You have to follow civil rights law. Now we're going to trust you to do it, and we're going to walk away. That's part of the reason we've seen such a muscular approach from this Department of Education, and to a lesser extent from the Equal Employment Opportunity Commission, because both recognize that time is limited to accomplish their aims and to root out the vestiges of discriminatory programming that was being masqueraded as inclusivity or diversity, equity, and inclusion, critical race theory, critical gender theory, the lack of viewpoint diversity, you name it. Higher education has been plagued for many years by sort of its own iconoclastic view of what is and is not good higher education. And this is the first time that the administration has really begun to shake the ivory tower. But the goal is institutional self-reform. I think the hope from the administration is that because they've had a couple of very big marquee voluntary resolution cases, that they will get the other universities who are smaller, less sort of public, less well funded in their endowments, that there will ultimately be future opportunities for that. So, a couple of specific cases. I'm sure we'll talk some about some of the cases today and in the Q&A as well. University of Pennsylvania was one of the first shoes to drop. We all remember, based on its trans-inclusive athletic policies, that it signed a voluntary resolution agreement on June 30th of 2025. There was no fine imposed. Actually, they came to the table. They said, we're going to come to terms, whatever your terms are. That's great. We admit that we've engaged in malfeasance. And the terms were that they had to cease sex discrimination under the guise of transgender rights or gender identity and uphold Title IX's protection for sports, housing, and facilities. And that was also in alignment with two of the executive orders, some of the first out of the gate, I might add, for the Trump administration in January of 2021. Or 2024, rather, when he took the oath of office. Columbia was the next to go. This was a bigger case. They signed their resolution agreement on July 23rd. That involved a $200 million fine from the U.S. government and an additional $21 million class settlement fund established by the Equal Employment Opportunity Commission for employees who had been subject to anti-Semitic discrimination by virtue of their national origin and identity at Columbia University post October 7th. There were a number of significant reforms here. Among them, there were removal of race-based outcome programs, annual public disclosures of de-identified data, for example, by race, sex, or GPA, just so that the raw data would be available to the public, policy adjustments prohibiting matched single-sex housing and sports participation with individuals based on gender identity, better campus discipline. For example, no unauthorized encampments, enforcing speech zones fairly and honestly and impartially across the board, regardless of perspective. And then prohibitions on face masks, except for religious or medical reasons. Also, some anti-Semitism initiatives for hiring, for example, for intellectual diversity, appointing a Jewish student liaison, stricter screening for international student admissions, and a 20% reduction in financial dependence on international tuition. This was a pretty substantial, pretty weighty voluntary resolution agreement, lots of terms, lots to come to the table with compliance, a very hefty fine supported by the EEOC's class settlement fund. Columbia was the one that really got its knuckles rapped, but this is a university that really stands alone as sort of the vanguard for how to do things wrong and might be, I think, now an example on what not to do. Brown University followed shortly thereafter. They signed on July 30th with a $50 million fine payable over 10 years to state workforce development organizations, so that they could comply with anti-discrimination laws. And the agreement resolved outstanding issues through general self-reforms, potentially including some oversight mechanisms. And then, of course, my alma mater, at least for law school, the University of Virginia, they signed later, fall, October 22nd of 2025, no fine, outcome centered on resolving outstanding compliance issues via self-reforms with a little bit of external oversight. So all things considered, they got off the hook substantially easily. And then last but not least was Cornell, the shoe that dropped on November 7th, 2025. That involved a $30 million fine. And the agreement between the Department of Education and the university addressed outstanding matters through, again, self-reforms and potential monitoring, much like University of Virginia. So again, sort of wrapping this all up, the Trump administration's approach to education reform is an unprecedented shift compared to previous administrations. While prior progressive-leaning administrations have utilized resolution agreements to advance their own identity politics agenda, expanding bureaucracies, for example, for diversity, equity, and inclusion, expanding trans student health services at taxpayer expense on college campuses. The Trump Department of Education has totally inverted the strategy. They really want it to be back to ground zero and value neutral. Deployed these agreements as part of the multifaceted campaign to oversee complete reform in higher education. There have been, as I mentioned, over 50 higher education executive orders by fall of 2025. And then initiatives like the Compact for Academic Excellence to dismantle discriminatory practices, curb foreign influence, promote efficiency, promote meritocracy have also come along, as have the portals for reporting of foreign funding gifts, as have the rulemaking on transparency and admissions data, as have the substantial fines from these voluntary resolutions. What we see here is a comprehensive nut of education reforms for which really the voluntary resolution agreement has proven to be the cherry on top with sort of these supporting structures underneath, all with varying degrees of success, it seems to my mind. And I'd love to hear what Chris and Dave, you both think about this. But I think the Compact for Academic Excellence has fizzled out largely. I don't think that landed the effect that the administration thought it potentially could land. But, ultimately, this is a very active administration, which some could argue, devil's advocate here, that it's fundamentally at odds with the general proposition of dismantling the Department of Education altogether. They want to do a lot with a very little, and they want to do it before they can turn the lights out right before the oath taking in 2029 for whoever that may be. So it's a positive alternative to the often contentious resolution agreement process. They have offered as well, and this is again one of those supporting corollaries, not just the reporting portals, not just the rulemaking, not only the compact, but they've also instituted, and this happened just a few days ago, $169 million grant competition that's been applied for by more than 70 organizations, colleges, and universities to advance a number of the education department's priorities: accreditation reform, promoting civil discourse, short-term workforce development programs, and advancing the use of artificial intelligence, for example. This is yet another one of those sort of supporting pillars that comes underneath the voluntary resolution agreement. They really have taken a number of sort of prototypical bad actors, the ones who are most visible, most prestigious, and most well endowed. They have used those as targets. And then behind the scenes have instituted some more subtle reforms that are going to allow people to really compete for what they think is the best vision of American higher education. So with that, I'll turn it back to you, David.
Thank you so much. That's wonderful. Um, Thank you very much. And I'm now going to turn to Christopher Shore, otherwise known as Chris Shore, who I believe has a PowerPoint, which ought to be working.
Yes. Well, thank you, David. Thank you for that introduction, and thank you, Sarah, for the great background. So I believe we're on the first. Yep, there we go. First page. So I'm Chris. I'm here from AFPI. We can let me see. So we can go to the next page. So wasteland case resolution agreements brings clarity to the Trump administration's education reform agenda and strategy, focusing on the central element of that strategy, which, as the title suggests, is case resolution agreements. And I think this clarity is helpful for lay audiences, many of whom may be tempted to view the administration's sweeping changes as purposeful chaos, sort of destruction for its own sake, or as some would say, to own the libs. But in fact, there are coherent goals, and there is a coherent, if imperfect, strategy for attaining those goals. And the limitations of that strategy will be of interest to more informed readers, particularly those allied with the administration's higher education reform agenda. The focus on the need for monitoring by external parties should spur those of us in this camp into action. And the suggestion for monitors to focus on elite schools with signed agreements is a prudent one. And the checklist is helpful. So well done. Regarding the broader conversation around the themes of this paper, I offer the following, which I'll go through briefly now. Next slide, please. All right, so starving the beast. One of the most useful aspects of the paper's recommendations is that they do not rely on Congress to do anything, which of course plays to Congress's strengths. They instead look to external actors, as noted, which may include some of the individuals gathered here today and their respective organizations. Now, speaking as one such individual, there are things our organizations can do to help Congress advance the administration's reforms in a roundabout sort of way. And I'm thinking here about the recently passed Working Families Tax Cuts, better known as the One Big Beautiful Bill. The paper rightly notes that the Department of Education's resources are scarce, and I would add that DOJ's are as well. By contrast, the institutions in question, or at least the elite ones, possess extensive resources thanks to university endowments growing at 7% a year. So when we think about elite universities taking it on the chin in terms of a fine or a violation for civil rights law, and then simply waiting out the administration, fully intending to resume discriminating at a later date, we have to keep in mind that all of this is enabled by their extensive wealth. So we could take their wealth from them, and taxing endowments was a good start to this end. Taxing endowments at the full corporate rate would be better. This is something Congress can do through reconciliation. And like so much else, future Congresses can undo this action, but then future Congresses can redo it. All the major provisions of the reconciliation bill deny resources to elite universities, whether by limiting the programs they can offer, limiting student borrowing, shifting students towards workforce-oriented programs that reduce demand for traditional higher education. And all of these reforms also happen to be good policy in their own right, so there's that too. But the point is, as we ascend the ladder of difficulty with regular legislation subject to the 60-vote filibuster at the top and monitoring by external entities at the bottom, the second or maybe third rung on that ladder is probably things Congress can easily do or easily enough do through reconciliation that have the effect of weakening institutional power of the higher education sector, at least especially in the elite aspects of the higher education sector. And we in the advocacy and the think tank world can advocate for those things. Now, implications for the civil rights state. The civil rights component of the administration's higher education agenda is revolutionary in both senses of the word. It's a revolution in the sense of returning to original purposes if one goes by the key legislation and public sentiments surrounding those bills. And I'm thinking here of the 1964 Civil Rights Act in particular. Restoring equal treatment under law is revolutionary in that sense. But it's also revolutionary in the more conventional sense in that it turns the civil rights the civil rights state as it has operated in practice on its head. And because that is in practice, and this has been pointed out by Christopher Caldwell and others, DEI and the associated abuses are the end result of decades-long pressure by government entities seeking to remedy outcome disparities under authorities provided to them by civil rights law, albeit perversely applied because in most cases those authorities address unequal treatment rather than unequal outcomes. And this goes to the disparate impact comment earlier. And I'll note that AFPI has a recent report on this topic. So the revolution is not that all of this has now been undone. Rather, it's that what used to operate as a one-way left-only ratchet now operates bidirectionally. And it's easy to forget that every Republican president following LBJ could have repealed the executive order creating affirmative action, but none did so until 2025. And I think it's worth thinking about the civil rights state in these terms because today their voice is on the right, and I don't mean groypers, I mean serious post-liberal thinkers who advocate uprooting the civil rights state entirely at the very moment that the right has seized hold of it and put it to good use. Okay, moving on to viewpoint discrimination. Next slide, please. So these are estimates of viewpoint discrimination against conservative faculty constructed from survey data. So these are derived from faculty members' own admissions of their willingness to discriminate against their conservative peers. We should regard these numbers as the floor rather than the ceiling. As noted by Eric Kaufman, if 1 in 5 faculty would discriminate against a conservative colleague applying for a research grant, the likelihood of that candidate being discriminated against rises to 4 in 5, assuming a randomly selected 4-person panel. In my view, viewpoint discrimination is the most glaring missing piece from the recent case resolution agreements. This is not surprising for several reasons. First, viewpoints do not possess immutable characteristic type protections under civil rights law. Second, judging by the responses to case proposals, rather, for the settlement agreement case resolution proposals from the Trump administration, this appears to be a hill the academic left is willing to die on. And third, it's clear that education reformers on the right, even in the administration, do not agree on how, but more concerningly, whether to address this issue. You may recall the Columbia settlement included provisions to bring viewpoint diversity to its Middle East Studies program, but not the university as a whole. It did not, for example, require increasing hiring of conservative faculty. It could have used the same approach across departments, i.e., appoint an administrator to review faculty hiring with an eye toward closing egregious viewpoint gaps by admitting a critical mass of conservatives so that students would have the opportunity to encounter good faith presentations of alternative views. And this is essentially what was called for in the Harvard letter. So, what I would humbly suggest is that if viewpoint discrimination is the hill the left is willing to die on, there's probably a good reason why. Next slide, please. So, oh, actually, you know what? Yes, no, this is the right slide. Okay. So this is from Honeycutt 2024. It's an unpublished, well, it's a published working paper. The line, it's pretty self-explanatory. The line, blue line would be left and liberal and far left identifying faculty. The red is for conservatives. Um, so this is the trend going from this is among faculty 1969 more or less to the present day. Next slide, please. So what I did here is I just plotted 2 points using Gallup data. So it's obviously more noisy in between, but the point really is just to illustrate that what's happening in the academy does not at all match what's happening in the wider society. Next slide, please. This is, in my mind, a little bit more interesting. So another NAS piece, actually, by Langbert and Stevens, 2022, estimated the proportion of registered Democrats and Republicans among a large sample of universities. A graph was then made using some of the most egregious examples at the most elite universities. So you can see it's 99% to 1 at Harvard. If, by the way, if you can't read the numbers, the blue is registered Democrats, as is the convention, or has been since the I guess the 2000 election. What I plotted here on the right are the representation quotients. So this would be the representation of Republicans and African Americans in these same universities um, in as a fraction of their total national respective populations. So um, the national reference population, the denominator in the case of Republicans would be Republican self-identification nationwide. For African Americans, it's, I believe, 12.8% or 12.8 or 12.9% of the national population. And then we get the African American faculty numbers from IPEDS. So these are not, in neither case are we talking about independents who maybe lean right or lean left. So these are sort of the two categories are Republican, Democrat, independents excluded, and then obviously African Americans. So why is this interesting? Well, if we recall prior to Students for Fair Admission, the argument for essentially setting aside what the 14th Amendment civil rights law required in terms of explicit racial preferences through affirmative action was that, at least in the court's view, if you had a critical mass of underrepresented students from underrepresented groups and they have a coherent perspective, which I can argue that that's kind of essentializing, but set that aside, then you needed to have that critical mass in order for that viewpoint to be represented. So ironically, it was a viewpoint diversity argument. And so here what we have in higher education is viewpoint discrimination overtly to a larger degree than we see, at least as evidenced by the underrepresentation, um, which is sort of ironic. Okay, so what I would add to this is that these are the same schools, the ones with the most egregious lack of faculty viewpoint diversity, that are also the worst places for campus free speech, according to FIRE. I have that graph at the end if anyone's interested. Moreover, every single university on this list had an encampment during the 2024 pro-Hamas protests and riots. And that's not a minor thing because only 4% of four-year degree granting nonprofits and publics had encampments, but these all happen to be in that category. I would argue viewpoint discrimination is the wellspring of the broader cultural rot in higher education that the administration is trying to address. So whether we're talking about DEI, anti-Semitism, or gender ideology, The systematic removal of countervailing forces, of any countervailing force from the intellectual climate is what has allowed these echo chamber dynamics to run wild on the left. And as we see in the emergence of assassination culture, which is downstream of the notion that speech one deems to be offensive is tantamount to violence, an idea that is so absurd that it would be indefensible um, if there was anyone around to defend it, or if there was anyone around rather to criticize it. And thank you. That's all I have.
Thank you so much. Yeah. So this is wonderful, and I am going to say yeah, I can like try to tee up some conversation first, but I'm hoping as much as possible to get Q&A. We have one question already, and I'm encouraging everybody who is watching this, put in more questions as quickly as possible, because we want to respond to you ideally, and not just, it's fun to repeat ourselves or think, but responding to you is better. So the first question is from Ed Geringer. Um, I see that some of these resolutions have universities agree to abide by federal law with regard to race and sex discrimination. But what is the legal justification for asking them to diminish their financial reliance on international students? To any and all.
Hmm.
Well, I
Sarah,
can
I
take
see
the
you nodding your head.
Yeah, I have to tell you, this is going to be one of the more controversial attempts that the administration has made toward effectuating its own ideal preferred vision of higher education. A federal judge has already blocked the administration from barring foreign student enrollment at Harvard, for example. He is unlikely, I believe, just based on sort of the composition of some of the federal trial courts and where he is right now, litigating some of these cases, because they do have a tendency to coincide with districts that are not generally favorable to more conservative textualist, originalist interpretations of the law, not to be victorious. This may ultimately be a question for the Supreme Court. To my mind, all I've seen so far in terms of legal justification is the ability that the Department of State has to revoke, limit, rescind, revise student visas for any one of a number of criteria. So DHS has, or Department of State has, a fairly wide latitude in that respect. But whether or not the administration can unilaterally bar a university from enrolling a certain percentage of foreign students, and again, we know that that was part of the settlement agreement, the voluntary resolution agreement with one of the other universities, with Harvard specifically itself, and the judge immediately enjoined that, struck that provision down, and said, we're going to hold this in abeyance until we get through the entire factual record on this. I think it's going to be something that's going to have to be roundly defended in court and may ultimately make it to the United States Supreme Court. I'll give you a perfect example. At Harvard's Kennedy School, for example, 56.4% of the Harvard Kennedy School for Business are non-US residents. So these are students who are coming from other nations who are enrolled at the Kennedy School. That's tremendous, and it may be wonderful for viewpoint diversity, but I think the administration wants to make sure that there aren't any implicated affiliations with organizations or funding sources that could be problematic. Our organization, and Chris knows this, years ago published a report called The Little Red Schoolhouse about what we were then tracking as the influence of Confucius Institutes on college campuses, and how that was really a backdoor to the institution of CCP propaganda through the guise of learning about Chinese culture. I do think the administration is right to worry about that, particularly, but whether or not he has the legal justification beyond the Department of State's visa power is going to remain to be seen.
Chris, do you have anything to add to that?
Well, yeah, I would defer to Sarah on the law on this. I would just add the politics of it are pretty straightforward. These are scarce federal resources, talking about whether it's student aid, student loans, research grants that should be put to the interests for the interests of the American people, investing in our future workers, our future people. And so I think the politics of saying that, building up the human capital of foreign nations is not the primary focus of elite U.S. universities, not something we want to be funding. I think that's obviously that is a vital issue for it's both national security, it's all the things that we're talking about. I think you do find this recurring. So this is in the compact. It's in several of the resolutions as well. It may ultimately be something that has to be attacked through accreditation. But I think it's a worthy. So I would say we haven't talked much about the compact, but I would say that the items on the compact, whatever the final status of it will be, and obviously, is last I've heard, the administration is looking at reissuing it. I think those are all appropriate targets. How we get there, you know. But I think this is a worthy target on that list as well.
I have a comment from Ed, which is, but Chris, 70% plus of those students stay in the US, and many of them are among our tech leaders. I want, however, to
Yeah.
pause for a moment on the theory that this is possibly getting away from the mainstream of this evening's symposium. We can return to this, but I just wanted to have Ed's comment made public for people to have. Um, so I'm encouraging more comments from everybody. I am going to return to something I think that Sarah mentioned. In effect, the tension between not enough people there trying to do the job. And I must say, some of what our white paper is saying you need to have people outside it doing the job is because, yeah, there are shortages. How many people do you need employed to make this case resolution strategy effective? How many do we have now? How many do you think we need?
Too few and a lot more are the answers. I think
Yeah.
so. The way this works, the Administrative Procedure Act, it conceives of certain periods of time in which voluntary resolution agreements must come to a terminus, either one way or the other. The APA guides very closely, and rightly so. It's been a helpful guidebook. I did not think I would become expert in administrative law, but that's what happens when you go into a federal agency and you make federal rules. There are certain procedures where, for example, you have to determine whether or not you're going to open or close a civil rights complaint within 180 days. And there's a certain period of time in which voluntary resolution agreements must transpire. It is difficult, if not impossible, statutorily for the administration in its extant form to be able to achieve all of the aims of the White House while also sort of tending closely to what they inherited as a significant backlog. When I was in the administration, for example, I was there during the sort of onset and height of the COVID pandemic. And so all of the DC leaders were all sent into the field back to our homes from wherever we were. And our case productivity level actually increased to 19%. I think we were all
Mhm.
thrilled not to have to commute to DC during that period of time. So it can be done. It certainly can be done. But I think right now, it took an approach of, all right, let's cut as much fat as possible. Let's, swing for the fences in interagency agreements, right? We've seen the IAAs on a lot of these things like Department of Labor, Department of Health and Human Services, all great things, all geared toward an ultimate downshift and dissolution of the Department of Education. But as we all know, it can be very hard to get over a 60 vote threshold in the Senate for a filibuster to eliminate and rescind the Department of Education Organization Act, which is what you would have to do. So these are wonderful anodyne talking points. We've been talking about it since 1980 with Ronald Reagan, who ran on that campaign promise. Listen, I love it. I love the idea of sending education back to the states. I think for purposes of boots on the ground, both in higher education and K through 12. And I've got experience in both.
Mhm.
I think there really could be, I think, better messaging about how some of these essential supports and programs will be unaffected, even though there's a lot of moving pieces right now at the federal department level. We're seeing the IAAs, we're seeing a lot of downshifting, we're seeing the riffing of 7 regional field offices, a lot of staff laid off, a lot of programming that has been eliminated. All of these, I think, are good things in the aggregate, but in terms of the nuts and bolts of daily operation, having been on the inside, I would be one of those attorneys who goes, I'm going to have to work until 1 o'clock in the morning again tonight. So, and listen, I know the attorneys who are at the department right now. They are stellar. They're absolute workhorses. I think for my part, if I had to do it all over again and I were queen for a day, I would have waited until we were sort of at a maximum capacity to be able to effectuate some of these aims before riffing like 70% of the staff. So,
Yeah. One thing to keep in mind for the audience is that dismantling of ed transfers authorities horizontally and as well as vertically. And so when we're talking about ed working with justice, now it's just justice, but those authorities presumably all transfer to justice and they continue. And these are conversations we've had as well. But yeah, there's no question that simultaneously downsizing ed and then massively expanding its role is challenging. One of the things I know I mentioned this in my comments, but I like the sort of outsource this to external parties idea. And I was just glancing, there's 900 Turning Point chapters on college campuses. I mean, so I think, we've seen the Shirley sort of video investigations involving Somali fraud in Minnesota or involving welfare fraud by some Somali Americans and Minnesota. And so in any event, you can sort of imagine how this effort can be scaled and resourced. And I think that may be a very valuable thing for different organizations to invest into the future.
I'm curious as to what both of you think about attempts by the administration to secure viewpoint diversity. These are pretty tricky constitutional questions, right? So, there are only certain mechanisms that the Department of Education or the administration on the whole has to be able to effectuate that. And there's a really delicate balance between maintenance of independent governance and operation, while at the same time being beholden to federal civil rights law that, by the way, every federal funding recipient has to certify compliance with at the beginning of every calendar year. They all get the same form. They all have to sign the same certificate. So they go into the year saying, yes, I pledge on my honor, I'm not going to violate Title 4, 6, 7, and 9,
Yeah.
whatever. And so every year, it's none of it is surprising to any one of the institutions that receive federal funding. But the viewpoint diversity issue seems to be one of the more noxious issues with which we're dealing in higher education, because it is kind of, this hegemony that we've seen replicated over and over again, and heterodox opinions, whether it's on gender identity, whether it's on, all people being equal regardless of their skin color, seem to be increasingly disfavored. But, we've seen through the academic compact, and that is, to my mind, I think one of the more creative, if not effective, but certainly more creative opportunities to entice viewpoint neutrality and ideological diversity in higher education. But I'm curious as to what you both believe about the success of the administration in securing that up to this point.
I got to say, by the way, you anticipated what was going to be my next question, which was going to be directed to Chris by way of,
Yeah.
equity, parity. Yeah, and in effect, if viewpoint diversity matters, what precisely are the constitutional and legal justifications? Chris, you made it sound as if, in effect, one would be building on Supreme Court arguments which held there to be an interest in viewpoint
Right.
diversity to justify, affirmative action, etc. Um, but how should I put this? To what extent was that implicit? To what extent was that a formal holding? And to what can one use other pillars to build on this? So I'm going to turn this
Yeah.
first as a question to Chris before I try to think if I have an answer.
Yeah, well, I certainly wouldn't try to dream up something as loosely constructed or as what the court did to keep affirmative action going, because I think that does violence to the Constitution. And I think the core of the problem that we're dealing with here is that you don't have, as I mentioned in my comments, you don't have immutable protection or immutable characteristic style protections for viewpoint diversity. So you do kind of have to go at it a bunch of other ways. One of those ways that we're pursuing and we would encourage state leaders, if there are any on the call, to consider would be state compacts. The compact that the administration has proposed, of course, has some carrots and sticks, and we can debate whether the sort of whether the carrots are sufficiently enticing given the sticks, right? Because you're essentially committing to doing some things, but now the compact creates an extra source of leverage if you don't do those things. But what state governments can do is they can just say thou shalt not. And just boom, it's done. And that is in many ways, I think, more straightforward. Accreditation is the other shoe to drop here. I love the idea of grants to encourage voluntary compliance. And again, I think that if, ultimately the purpose of these institutions of higher, well, I don't want to say the purpose of these institutions of higher education is to advance the frontiers of knowledge and to disseminate that knowledge. The federal government's interest is that those things happen and that they benefit the American people. And if the public interest in higher education is not being served, and you cannot advance the frontiers of knowledge if you're artificially circumscribing the debate and excluding half the conversation, and right, because you have to contest ideas, there has to be a give and take, people have to be uncomfortable. You don't change paradigms if everybody's comfortable, right? So if none of that is happening, the federal interest is not being served. And so Congress should absolutely rake them over the coals for this. And I've suggested taking their money. I don't have a problem with that. I think if they're not serving the federal interest, we should find various ways to incentivize them to do it. But yeah, in terms of the sort of silver Title VI style silver bullet, I mean, we don't have one. Um, yeah.
I've now had a chance to think for a minute or two. Um, the trouble here, as in many places, is that ultimately a judicial tool is not perfectly suited for getting people to do what they don't want to do.
Hmm.
And how should I put this? People who are best suited to reform the university obviously ought to be the people within the university. It is their malfeasance and nonfeasance that's at issue. All external tools have some limitations.
Hmm.
The getting into the weed solution is, one, politics, the finances, although again, state legislators may be a little nervous about, say, cutting off massive amounts. To get into a reform of the selection of the higher administrators, above all in public universities.
Hmm.
And what I would say in particular you want to aim at is, this is, by the way, incredibly wonky, redo the selection committees that select candidates for president and dean. This is a limited body of higher administrators, in effect having faculty selection committees, standardized search people, but in effect, any veto from within the university means that you will never even get as a possibility somebody who is mission directed for reform. You therefore need a somewhat complicated bit of reform at the state level, above all, to get new selection committees for, again, for any particular public university, say a dozen people, 12 to 20, the president and the top deans. Once you have people who are mission dedicated reformers in that crucial critical mass, they can begin to do the administration within the university. And this is, how should I put this? There's a great many things which get you a proxy for intellectual diversity. The various civic centers are a wonderful way as a proxy of getting you there. But
Yeah.
ultimately, you need to get that critical mass of people who are willing to administer, for liberty, for, equality, for intellectual diversity.
Right.
I will say, by the way, that the new civic centers are, among other things, good as training and a critical mass of people who can plausibly serve in these higher reaches of public university higher administration. And that's a critical purpose.
Yeah.
Um,
And that's a real
this is
limitation right now. I'm sorry to interrupt, but like what you could conceivably build a pipeline with no people in it.
yeah. And in fact, what I'm giving you is a somewhat complicated answer, but what I'm trying to say is I do think ultimately what you need are people who are the actual administrators within the university trying to do right. And if my particular complicated solution isn't ultimately the right one, some other solution to get you to that end game is what I guess I would say.
No, I think you're actually right, David. I think we can't really overstate enough the importance of university governance and structure. Because really, at the end of the day, the leader of the university is going to be the one to set the intellectual tone and the ideological cadence, right? And either it's going to be, sort of a silo, it's going to be an echo chamber of certain perspectives, or all is going to be welcomed. I'm thrilled. One of the first things that I was thrilled to see, and I've served on two university boards, including on George Mason University, which was, as you know, plagued by multiple investigations and findings of discrimination, and a voluntary resolution process had started, among which required Dr. Greg Washington to simply apologize for his use of race and his race preferencing in higher education, employment, and staffing. And he refused to do that. Could have avoided the hoary eye of the federal government and its, sort of long arm of executive enforcement. Refused to do that. One of the things I was delighted to discover at Florida Gulf Coast University was that on the homepage, it talks about their commitment to intellectual diversity and the viewpoints of everyone being welcome. And I thought, what a nice change. And in increasing measure, less common in higher education right now. But because we know that university chancellors, university presidents are the ones who set the intellectual tone, they are the CEOs of these institutions of higher education. Those individuals who pick those chancellors or those provosts or those presidents really have a very unique calling to make sure that they're hiring the right people to institutionalize that kind of viewpoint neutrality.
Yeah, so I agree with all this. I think, much as DEI was sort of a kind of everywhere all at once sort of phenomenon, I think, direct legislation, accreditation reform, university governance reform, the migration of students away from there's been a big southward migration of a lot of students over this issue exactly. It's not like they're finding these right-wing universities. They're just not as radical. I think there are many ways to attack this at the same time. I think there are sympathetic voices on the center left who understand that viewpoint diversity is not so the utility of viewpoint diversity is not actually that the minority opinion wins out. It actually improves the overall quality of thinking across the board. It's a just a good practice at a certain point. And I would add too that is radical, if someone is tempted to think that these conversations are sort of at the margin, the goal is not perfect parity. I know I just threw up representation quotients, but the idea of a critical mass is not that, 45% of your university be staffed by Republicans. We just want to give the students some sense that there are alternative perspectives to the one-sided narratives that they get pretty much anywhere they go. And I think, I mean, and it really goes back to the mission of the university. It's a liberal, classical liberal position that we're arguing for here.
Thank you. I'm going to go to another question. Yay, a question from Paul. How much of this is trying to use rules to make up for lack of character? To any and all.
Yeah.
Okay, actually,
So we're thinking rules in terms of, in other words, the regulatory process. For lack of character for bureaucrats in Washington, or lack of character for individuals who are in positions of governance in higher education.
I'm going to
This could be
rephrase.
very loaded, David. Be careful how you answer.
I blame everything on the wording on Paul. Hi, Paul.
Well,
No.
yeah. One thought is that remember that the um, people respond to incentives, and so when you create structures where, for example, they have to have diversity statements in order to even apply for a position, or they have to engage in these sort of ritual self-flagellations about privilege or whatever. Like you're creating the layers of rules, unfortunately, produce the character as well.
So I would add, I mean, for the character, I mean, there is this idea that, in effect, civil society, freedom, the republic run when people are self-controlled. They don't try to take advantage. I mean, that how should I put it? You don't cheat all the time when nobody is watching and just it's only when you get away with it. You try to be good, to be virtuous, to give in the academy, make sure that you're not simply trying to engage in factional warfare, disguised as truth seeking, thinly disguised.
Hmm.
Um, and the idea would be that indeed the university has lost this ethos. If we call character ethos, it's Greek and it sounds better. And I guess a professional ethos, if I'll make it even more bewordling. Um, so yes, I would say this is unfortunately the loss of a self-regulating professional character of the universities. And yes, it is unfortunately a shift towards having the government, take up the slack. This leaves the question of, if you believe that you need to recreate that ethos, does this indicate that you despair of what government can do, or do you think of government reform as a way to help foster a reform of professional character, recognize thinking that the government reform is perhaps necessary but not sufficient? I am perhaps hinting, I am leaning towards the necessary but not sufficient. I think we have to recognize that character is professional character really matters for the university. We have to recognize that what the government will do won't be enough, but perhaps that we won't be able to get there unless we use the government as part of the solution. Anyway, that's me
Hmm.
starting out. Do either of you have things you want to say that differ, argue, etc.?
Yeah, I lean towards I don't lean strongly towards the sort of maximalist libertarian view here. I think that, I think that a lot of time, so by analogy, laws start out as customs that everyone agrees to. And when the society gets to a certain scale, they find that everyone doesn't agree to them anymore and they have to write them down. And so, I mean, this is kind of what we're talking about here. And so, and the other thing that can happen, of course, is you can have drift over time. And so, those of us who say that, well, no, the other word other than ethos might be virtue, right? Uh, we're saying, like, no, actually, these things matter and we have to enforce them. Now, that does signal a decline has happened. Of course, we know that decline has happened. So, it's not admitting it is not a, it's not a step backwards in any way. But so, no, I do think. I think, we get back to a period in which there's a widespread agreement. Maybe the postmodern sort of understanding of everything is relative, and therefore we pursue power, and therefore, we sideline the perspectives we don't like. Maybe we get past that and come to a new equilibrium. But I think for the time being, we have to work with the tools we have. And I think the public interest has been left out of this conversation. The idea of universities directing themselves, sorry, like, no, just no. I mean, especially if get left to their own devices, they'll discriminate against their peers and exclude them from the conversation. Well, it's not in the public's interest that you do that. And if you'd like to continue to be funded, then you don't get to do that. I mean, that's kind of my view of it.
Sarah, did you want to add to that? I am going to focus on one last question before we get to our conclusion. Sarah, you had mentioned the elimination of disparate impact, which I'm going to say, in fact, I think this is crucial.
Yeah.
One, da, 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 da. Can the elimination of disparate impact be done effectively by case resolution, given, among other things, that there is some congressional support for disparate impact, which we are not yet, I think, in a place to get rid of?
Yeah, and I think the Supreme Court has been petitioned multiple times to ultimately revisit some of its previous holdings in Adarand and Griggs versus Duke Power, both of which identified what they called as the twin pillars of discrimination, right? The direct discrimination and the indirect discrimination that is essentially disparate impact. They have been petitioned. They have yet to revisit those two cases. The Department of Education has issued formal guidance saying we will not, for purposes of our anti-discrimination law, whether in Title VI or Title VII through the EEOC, apply disparate impact theory. It is only evidence of direct discrimination that we will be pursuing. I think it's the best with which the department has to work right now. Conservative scholars, again, have been calling for this for the better part of generations, because in very much the same way that we saw in the case relative to employment discrimination on by a straight white woman who brought a claim under Title VII saying, I'm a member of a majority class. Do I have to meet a higher evidentiary burden simply because I'm not a minority? She had been passed over by a lesbian woman and a homosexual man. And she claimed, using the Bostock analysis, that both under sexual orientation and sex-based theories of discrimination, that she was being discriminated against. She was otherwise perfectly qualified. She had met all of her metrics. And so the underlying court had determined in the case that she had to meet a higher evidentiary burden because she was the member of a majority class, and she had to prove that she was the unlikely individual working for an employer who was going to discriminate against a majority class member. In much the same way, disparate impact does really violence to the language of anti-discrimination law, and nowhere in implementing regulations or in application does it ever say, oh, and by the way, you can also violate the statute if you don't mean to discriminate, but you have a policy that actually ends up discriminating. It just flies in the face of what anti-discrimination law is supposed to do from the outset. So I think based on what the administration has right now, which is a Congress that is potentially not keen to revoke the use of disparate impact or amend Title VII or Title VI, or to rule make on either to clarify that, I think the first thing to do is what the administration did, which was get out in front and get out early with formal guidance saying, this is our official government position. And then let's see what can be done through rulemaking so that we can take some of the bite out of some of these bad judicial interpretations.
And I would just add and kick it over to Sarah on this. Sorry, I know you just talked, but there is a Title VI, Title VII distinction here that's very important in the context of disparate impact. The 91 Civil Rights Act amended Title VII. The disparate impact is, as I understand it, was allowed under Title VI, but not required. And so they have all kinds of leverage in the context of higher education that we don't have in employment. And that is for the broader civil rights reform agenda of restoring, the original meaning of the sort of pre-91 understanding of the text. I think that is a real thing. But I think that in turn means that the next administration can flip around the Title VI rules on disparate impact as well, in theory.
That's exactly it. Yeah. So it's sort of, interpretively allowed under Title VI for education purposes, but under Title VII, it's directly incorporated. And the Supreme Court has noted that is sort of this other twin pillar of race discrimination in employment. Listen, I don't think it's supported by the congressional text, history, or mission of the Civil Rights Act in and of itself, but bad judicial takes are for another day. We could do a whole webinar on that. But I do honestly think that Chris is right in that we've got more sort of play in the joints with Title VI than we do with Title VII, but you got to start small, right? And for this administration, first, it's informal guidance. Second, it's rulemaking. And then we see what we could get done in Congress.
Thank you. So it's 3:27. What I want to do then is get some final statements from the two of you. Then I'll have a sort of a final statement as a participant, and then just a final statement as a moderator. So if I might, same order perhaps, or roughly. Sarah, may I ask you to go first? And final 30 seconds, minute statement.
Yeah. So I think this is a multifaceted approach to education reform. For those of us who are in the space, right, we wonks and we education lawyers, it's what a time to be alive, because every one of us, we have no idea what we're going to find when we get on X every morning. The next thing you know, it's, there's a new academic compact coming out, or a foreign funding portal, or Columbia's just coughed up $200 million and $21 million for an employment settlement specifically related to anti-Semitism and employment. So this is, having worked into the previous Trump administration, it is breathtaking in its, I think, expanse, its speed, its muscular application. But I think there are a lot of good things to take from it. We know we have a problem in higher education. We know that a lot of these iconoclasts have got to be busted up. 34% of Americans don't think higher education has a value anymore. They don't trust higher education administrators or leaders. As somebody who is in the governance of a higher education institution and has two children in institutions of higher education, we know the value exists. We know higher education is still exceptionally valuable to the creation of future careered Americans who are going to contribute to the economy, be able to buy houses and to have families. But to be able to do that, we don't want to send them off to school where we know that they are going to be proselytized into one way of thinking and will essentially come out on the back end 4 years later as sort of these progressive agitprops, right? I really want my kids to just go to college and learn how to do algebra and botany and, all of the normal things that kids should be learning. But I think the administration deserves major gold stars for creativity, for level of aggression, and for speed of adjudication. And you can argue whether or not those are good or bad, but I think those are some of the hallmarks. And I think those are good things that we're seeing from the administration right now.
Lovely. Thank you. Chris.
Yeah, I agree with all that. I mean, I would add that uh, I think I forget the age, but it's several. It's measured in weeks, at which point that an infant can tell the difference between mothers and fathers, and so there's a degree to which actually going to traditional higher education at this point unlearns. Involves a process of unlearning in terms of the incorporation of gender ideology, but also the basic notions of fairness that we grew up about, treating people the same regardless of race and things like that. So there's an enormous need for reform, and I'm grateful that that there is the flip side of that need is there's something for all of us to do. And I would add that I think again, and I mentioned this, but I think that this white paper makes a good contribution to that conversation in that it turns the focus to to one of the places where it can be the most useful, which is maybe not where those of us, at least in the think tank world, are normally thinking about, which is sort of almost like being investigative journalists and going out there and sort of digging around. I know Defendant Ed actually does that stuff, but I think that's a very useful contribution to the broader to the moment.
Thank you. And look. Yeah, so basically, the point of this was indeed to, try to contribute in terms of ways to actually make this reform work. And how should I put this? Sarah has been optimistic. I do faintly worry that the government could use some help. So yeah, that was the point. The government can use some help, but it can, I think, be done usefully by all of us. I wanted, however, to close actually with there was a last comment by Paul question. There was a time when intellectual integrity meant that all sides of an issue were presented in a full, robust, honest way. How do we recover that? And in effect, our entire webinar, many of our webinars, are about the how. We're trying to figure that out. But I thought that comment was useful just to remind us of the why. And and this is for the National Association of Scholars, institutionally, you know, we love the university as it is when it performs properly. Presenting all sides of an issue, searching for the truth, the affection for intellectual inquiry. This is our motivation, even as we get into the how questions. And I guess I just want to say, we care a great deal about how we want to get back to a good university, a good liberal arts education, but we never forget the why, what we're aiming for. And then I guess, and I want to say, of course, it's not just the NAS, it's our panelists here, Chris Shore, Sarah Perry. They have some version of this in their minds too. The organizations they work for do as well. We all of us share a love for higher education as it should be. And I do want to emphasize this motivates what we do. So, so Paul, I wanted to thank you in particular for providing that comment and question, which I think was very important for us to go get back to. Um, so as moderator, then I just want to say, well, thank you. Thank you to Chris. Thank you to Sarah. Thank you to David. Thank you to the audience. We do this for you. We can't do it without you. Your questions, helped provoke, I think, a rather good and wide-ranging discussion. So very grateful for you. Keep on coming to these, keep on listening. And I will mention, for example, we will be having something on special education next week, Tuesday, January 20th, 2 p.m. Eastern. And another, white paper associated with wasteland as we pick up other issues. So this is not a one-off. We've got a whole bunch of these, and indeed everything else, we have. Um, want to say again, if you want to see this again, it ought to be up within 24 hours on the National Association of Scholars YouTube channel. If you have further questions or comments, please do send them to me, randall@nas.org, RANDALL @nas.org. And stay tuned to NAS and stay tuned to education reform. It's an exciting time to be alive. And anything you can think, do, comment, contribute, please come and join the great crusade. Anyway, thank you all. Take care.